Yes,
Do I
yes.
have them?
Yes, we can proceed.
Yes, I've supplied the artwork and the diary.
This person being presented before court, she rushed to the High Court by criminal revision number E1729 of 2024.
That is Halima.
Yes, Halima Samson Mongela. E1729.
That's a miscellaneous.
It's criminal revision.
Right. High Court.
High Court revision
Revision number.
E1729 of 2024. And that is the order you have been supplied with, telling you that it has stayed the matter, including the accused person's matter. And what has been stayed is only Halima Samson's Mongela's matter, which is coming up on the 22nd of January. On the 22nd January 2025, according to the order issued by the High Court dated 9th December 2025. The state had also moved to the High Court challenging the court's ruling which you have been supplied with. This person sought to defer plea. The state being dissatisfied with the ruling deferring plea moved to the High Court, and eventually the High Court has stayed the matter. We submit that even if the accused person was a relative of the said Halima Samson Mwangela, the orders staying this matter do not extend to him. They are impersonal. Thus, Your Honor, our submissions is that as we appear before you this afternoon, there are no stay orders in 1162 barring this court to charge the accused person or to deal with the matter dealing with the accused person. In that matter, I'm informed that there is a similar matter coming up on 4th of December. And that the accused person will present themselves in that matter or further orders. And that was the reason the warrant was suspended. Subsequently, Your Honor, the matter was mentioned on 5th December. And accused number 1 was said to be unwell by the counsel who was in court, Mr. G. Kamau.
So subsequently the matter was mentioned on
5th December. But the accused person was said to be unwell. First accused person was said to be unwell. The second accused person did not appear. The first accused person counsel presented a medical note dated 3rd December. which indicated that the accused person had been granted 4 days sick leave from the 3rd of December to 6th December.
What's the accused? Has been granted what?
From the medical notes, it says he has a sick leave from 3rd of December to 6th December. And he was going for further review on 9th of December. And thus the court fixed the matter for mention on 13th of December. Where none of the accused persons appeared. Counsel for the first accused person informed court that the first accused person was still unwell. There was no medical note which was presented. I'm not wrong. Your Honor, from my submissions you can see there is and we also in miscellaneous 435 of 2024. We have not been told there is nothing else attached to. He's a serial offender.
Sorry?
The mischief in that order, the reason they have not attached anything else, why they moved to the high.
Strongly object to the language being used by
Note that both of you.
serial offender, honestly. How can you?
We have an
At the end of
affidavit in
the
the
day.
position of bond
Yes.
in the file.
Yes, but so far, as we are talking, we are not yet.
The affidavit has been supplied to the accused person himself.
Are we through with the submission?
Not yet, Your Honor.
I need to look at this.
Yes, Your Honor. Your Honor, we are saying that the court is being made to believe that there is an anticipatory bail in this matter, while the accused person has various other matters. Let me not use the word serial offender. That is E862 of 2024, E469 of 2024, E469, E469 of 2024. And the issue of anticipatory bail has never been raised since 20th November 2024, when the matter was registered. And that's when there is nothing that bars this court from having the accused person take plea today. Thus, we trained that to be allowed to have the accused person take plea today.
On the 22nd of January 2025. So, and that is the date which was taken before court, wherein both parties were present. He has indicated that he is aware. The same was, is it suspended? Yes. Yes, he has used the word suspended, but he has not. Under what law does the prosecution have to set a mention before court when the court itself has already issued directions on a mention for a particular matter? Was there an application which was made before the court to have an earlier mention for this matter? There is no application. You are never served with any mention date for today. And even the court itself has never granted any date for today. If they wanted to review the court's orders or the court's date which was issued in the absence of any arrest warrant, then they ought to have approached the court through the proper ways. That is all. My colleagues will proceed.
You will not be able to attach it with any documents. The anticipatory order was given on 25th November. You have been told there were warrants which were suspended.
It was given on 5th.
We had this argument at the police station yesterday.
Yes.
And again, they have produced a new charge sheet to cover up the other mistake of arresting in contempt of the High Court order. This matter were coming up in Court 5. The court file was not brought in court that day.
So there is no record.
Yes, on the 4th. And that's why court gave a mentioned date of 10th of December. 10th December, the court file further mentioned date of 13th of December. The court now gave a mentioned date of 9th February. After court had been informed of the proceedings of the High Court matter, where the lower court file had been taken.
Sorry, this date in February?
9th.
After?
In the charge and the particulars of the offense. It is our submissions that the charge and the particulars of the offense in the two charge sheets are copy and paste word by word. Of 2024, and the same facts, the same charge. There is no reason given by the state as to why the same ruling of the court, or the court should depart from that ruling. On the charge sheet having, which are identical to each other.
Repeat that, Counsel, sorry. What did you say? Sorry. You said had Honorable Benmark?
If your brother now Denmark deem it fit to defer plea on a charge sheet before him, there is no reason given by the state why this court should not hold the same position on a charge sheet which is identical in the charge and the particulars and the facts of that charge sheet. And he directed that the two files be mentioned together in Court 5, and we deal with the issue of consolidation. This court has been misled that the accused person appealed the decision of the court. But the order supplied to the court indicates that the applicant is the DPP, which is a fact on the face of it. appealed, and in our response, we made further applications which have been granted by the court. We pray, Your Honor, that this matter be put to rest, plea be deferred, we wait the outcome of the High Court.
I had a lot already at my hand. Friday at 2 p.m. That is 20th.
Your Honor, before you time off, we need a specific direction as to whether we are.
One of the issues the court is going to determine.
I don't want to say anything at this stage because you've just come before me and I need to look at this file. And I need to appreciate what is happening. You know, as you know, this is not my matter. I cannot just make a decision without going through the file. I need to peruse the file. Yeah. And I know between now and Friday it's not even possible for me.
You know, on that issue of the prayer alone I've made, can we come back maybe to the court at around 4 to just to confirm, to give us a direction on that at 4 p.m.?
Not today. Right now, in fact, it's not possible.
Because there's issue pending whereby
it's not
right.
possible. Counsel, I would like, but humanly
Yes.
speaking, it's not possible. Yes, we've been sitting. We needed a break. I know each one of you, the prosecutors, have been exchanging. One comes in, a new one takes over. The court assistant, it has been the same.
Yes.
But I also need a break, and I need time to look at the file. Yes.
And they also be granted access to counsel at the station. We had challenges initially when we tried to access it.